Hey, Kevin.
Hello, Rebecca.
We are here for what reason?
Super Bowl.
Yes, we're here to talk about why I believe the Chiefs could beat the Eagles next week, even though a lot of people don't believe that they will. But no, that's not really why we're here. Why do you think we're actually here?
It's a readathon.
It is a new readathon.
So I'm guessing there are some things that happened last week.
There are some things that happened last week, some things filed, but most important, a big hearing, which occurred on Friday of last week.
Okay.
So I'm just going to go roll back a little bit and ask you this question. Do you remember who Gretchen Voss is?
That's the name of a journalist, right?
Yes.
She wrote one of the articles, was it Boston Magazine or
Yes.
Vanity? Okay. And that the prosecution wanted to get copies of her off-the-record materials.
Correct. They wanted her raw audio recordings of the interview and her notes. And actually, the Judge Cannoni ruled in favor of the Commonwealth on that and said she would have to give everything up, but she appealed that issue and had some people signing on with amicus briefs, the New England Press Association, the Reporters Committee for Freedom of the Press, and the Massachusetts Newspaper Publishers Association, the New England First Amendment Coalition, etc. So she filed that, appeal to the decision and basically said, my recordings are fair game, I guess, because they were on the record. I didn't use them all for the article, but they were on the record. My off-the-record notes should not be allowed to be taken by the state.
Made the distinction between the materials.
That's right. So also last week, there was another filing, which I just want to mention because both of these things came up in the hearing on Friday. The defense filed its opposition to the Commonwealth trying to exclude Richard Green from testifying at the next trial. Remember who Richard Green was?
I don't.
Richard Green was the defense expert on cell phone stuff, and he was brought in to testify about Jen McCabe's alleged 2:27 a.m. search, which said what?
House long to die in snow.
Correct. So he was their expert after the prosecution brought in a guy named Ian Whiffen, who works at Cellbrite, and this woman, Jessica Hyde, who works for the state, okay? So they filed a motion trying to exclude him as an expert in the next trial, as
because
they do.
if they can keep the defense from arguing that the search was made before the body was found, then all the better for them.
You got it. So that was also filed last week, but it's important to note that there was a supporting affidavit from Richard Green on this defense motion, which had some very interesting things in it. But first, you keep asking me a question here. Why don't they just ask Google, subpoena Google, etc.?
Yeah.
So apparently, there's a bunch of stuff that I didn't know because of when I started following this case. The defense filed a bunch of motions before the last trial, and one of them was a request to subpoena Google for the search database data. That request was denied by Judge Cannoni.
Okay.
So that's why they have never been able to get data directly from Google.
Okay. So it's possible Google has it.
100% possible.
Interesting. Wow.
It is interesting, right?
Because, I think to me, that's the whole ball game.
It is.
If you get this search before if you can prove beyond a shadow of a doubt that the search was made at 2 a.m., well, then, that's... That just supports the defense theory that John O'Keefe was out in the snow.
Right. Absolutely. That would mean that at 2:27 a.m., Jen McCabe was worried or wondering if he could die when he was out there.
Yeah. It's certainly the most damning piece of circumstantial evidence. Now, if it was shown, no, she actually made that search at 6 a.m. or so, whatever they say, it doesn't necessarily prove that he wasn't at the party and that the defense's theory is wrong.
Right.
But because that could go either way. But it just it would be a huge blow to the prosecution case as far as raising reasonable doubt. So okay.
So the one thing of note that I just want you to know is that she did make 2 subsequent searches at around 6:30 in the morning that are similar, both with misspellings in them, how long 'tis dying cold and what another one. And, there's a theory there that she was either still wondering that or that she was trying to replicate her earlier search from the evening. Who knows? But anyway.
I don't think she's savvy enough.
I don't think so either. But to be fair, her husband does work in IT, and that's something that's important to know, I think.
Okay.
So I'll get back to Richard Green in a minute because he does come back, and so does Gretchen Voss. So the Commonwealth also filed a new notice of discovery, which had a couple of weird things on it. One of the weird things it listed was more copies of videos from the Canton Police Department, including the driveway side exterior video, which I mentioned last time, which was the video that showed Brian Higgins pacing, talking to someone on the phone around 1:30 in the morning outside the police station. Now, keep in mind, since their expert went to the police station and the police showed them that stuff deletes after a period of time, that means the state has had this video for at least 3 years and never disclosed it before, okay?
Yeah.
So another...
Or never thought to do anything with it.
Exactly.
You know, it was just because it was sitting there.
A couple more interesting things in their notice of discovery to the defense. A anonymous email with attachments dated 1/18/25. It's a 4-page email with attachments. And an anonymous voicemail.
Okay.
I don't know why they would disclose it to the defense unless they were considered potentially exculpatory. I don't know. But also, why the hell would anonymous stuff even be in play anyway, right?
At this date?
Right.
After the first... okay.
But it was just sent like on the 18th. So.
Okay. Well, what is our sense that this could possibly hurt or help?
I don't know. I mean, it could be somebody saying, I know that someone inside the house did it and here's how. It could be someone saying, I know Karen Read did it and here's how. The bottom line is it's an anonymous thing. And obviously the state didn't do much to investigate who sent it. And it was sent over to the defense. So we don't know what that means. I just wanted to point out that it was in there because I have a feeling it may come up later.
Okay. Yeah, and you're right. Like the prosecution does have an obligation to share potentially exculpatory evidence,
which they have not done.
Which they really have not done. Have not done perfectly. Right. You got new people here, and they recognize. Yeah, because hey, an anonymous somebody from the defense could always place a quote unquote anonymous phone call to see if it gets passed around. So yeah,
that's right.
Okay.
So back to Richard Green. His part of this defense filing, his affidavit, remember I said it included some interesting stuff? Let me tell you some of the interesting things that it included. Of course, it explained why he's an expert. He owns a digital forensics company. He's a licensed PI. He has a degree and lots of training in this field. I think he's testified at like 60 trials, and Ian Whiffen, the prosecution expert, has testified at 2, including the Karen Read case or something. But the other stuff that his affidavit includes are so-called anomalies. All right? One anomaly is anomaly number 1. The most up-to-date version of the Cellbrite physical analysis reports 4,560 searches on Jen McCabe's phone, with only 1 search being marked as deleted. Guess which search was marked as deleted on Jen McCabe's phone?
House Long to Die in Snow?
Correct.
Okay.
So that was one anomaly. He goes on.
How many searches?
4,560.
Wow.
Yeah.
Wow. Actually, I don't even know if I could delete a search if I had to use my phone. But okay. Anyway.
Right. So that was a big one. So first of all, he had to request files being withheld from him 3 separate times. All right. He was emailed by Ian Whiffen on the eve of the trial in order to tell. Whiffen told Green that Cellbrite's new version of software would remove the quote artifact in dispute, meaning the 227 timestamp. Okay. That his software, this other software, Axiom, more precisely finds that at 227. That Guarino's own Axiom report shows the 227 pretrial, but the Commonwealth never turned over that exculpatory evidence to the defense, nor did Guarino testify to that. And that Guarino got into Jen McCabe's phone with a passcode that he entered, not unlocked via digital key, and that he has 2 hours of accounted for time with the phone. So those are all in his report, okay? And then he says he
got into the phone himself?
Yes. And then he says
someone gave him the passcode.
Maybe Jen McCabe did, but remember, she was allowed to delete a bunch of stuff from her phone before she handed it over.
Yeah, that's true.
So he basically says, it is my opinion based on a reasonable degree of scientific certainty that the 2:27 a.m. search artifact for Has Long to Die in the Snow, you ready for it? Was deleted by either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual. So he's basically saying that not only did the 227 search happen, which he also says he's certain of, but that the device was manipulated by a user or after the device was imaged, meaning that its report image would have been deleted, okay? That's just some of the interesting stuff his affidavit says, but it's kind of a bombshell affidavit. So there were two issues at this hearing on Friday. It was not a, Dober or Dobert hearing, which is the one where they, put him on the stand and examine him. And this hearing could have basically, the prosecution actually wanted that hearing, that the same kind of hearing that Dr. Marie Russell got for Richard Green. Okay. So that was one of the issues at this hearing. The other issue at the hearing was the Gretchen Voss issue. So that came up first. The Gretchen Voss issue, there was a relatively short section of the hearing on that. And Judge Bev Canoni basically ruled on that right away. She said the notes are no longer gettable by the Commonwealth, okay?
The off-the-record stuff.
The off-the-record stuff. And she has a very interesting quote about that. So Voss basically won, and Judge Beverly Canoni's ruling said, quote, in part, the Commonwealth has not demonstrated to the court that its need for handwritten notes outweighs the danger to the public interest in the free flow of information.
Right, okay.
And she basically says she came to understand the difference between off-the-record notes and on-the-record audio recordings through Voss's appeal.
Jesus fucking Christ. Okay, sure.
Why do you say Jesus fucking Christ?
No, it just reminds me of like halfway through the pandemic when the governor of Georgia said, "Oh, we just learned that you can be asymptomatic."
Right.
Yeah. Anyway, I don't know why that's the thing that jumped to my head, but yeah, okay. Just learning on the job.
Yeah, just learning on the job.
Just making a really important decision without knowing what the fuck how anything works. Okay.
So very much at issue at this hearing, the main event of it was the Richard Green affidavit and the state's request to exclude him and the defense's request to not exclude him from trial. Okay.
Sure.
So let me say this again. His report states unequivocally that Jen McCabe made the search at 2:27 a.m. on January 29th, and Ian Whiffen, the Cellbrite expert, he pushed an update to the software that removed that stamp. But at trial, Jessica Hyde basically says every tool she used except Cellbrite showed the 227 value. All right? She also testified, though, that she didn't believe that the search had been made at 227, but she did see it in her analysis. Now, here's what attorney Robert Alessi had to say about the Hyde versus Green take on that, okay, and why Green shouldn't be excluded.
Here we have Ms. Hyde, and in her report of 5/23/2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 22740 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees that it's an opinion issue.
So basically what he's saying is we're talking about two experts with differences of opinion here, and that is the whole point of bringing experts at trial.
Yeah.
So that's basically what he says. Now, when Hank Brennan got up, oh my God, Kevin, I can't even tell you how much I hate Hank Brennan. And I would be saying that if he were a defense lawyer. I swear to God, I would. He is so bombastic, and the stuff that he says is wild. He basically said that it was dangerous for Karen Read to be able to use this forensic data to defend herself at trial and thereby implicate a witness in a conspiracy. He said it was dangerous, okay?
He made the determination?
He made that
on behalf
determination.
of the defense that it was dangerous for her?
That was dangerous for her,
Oh,
yes.
She wouldn't want to do that. She wouldn't want to get exculpatory evidence now.
Now, keep in mind the other thing...
Don't make us do it.
Don't make us do that. Now, another thing that happened that was a funny moment, it was that in his speechifying, he kept using the phrase hashtag value to talk about, the veracity of the data. Now, what he meant to say was what the actual phrase is hash value.
Yeah,
okay?
yeah, that's right.
Now, would you like to hear what Robert Alessi had to say about that?
Yes.
The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right.
And by the way, this was not an uncommon thing during this hearing, where Alessi would take something that Brennan had said and just point out how either silly or dumb or inaccurate it was. One of the arguments...
He has heard of a hashtag,
of course
right?
He has, just
in
not
other
in this context. Yes.
Okay, right.
But what's interesting, too, is that, Hank Brennan criticized Richard Green's affidavit because it had a couple misspellings in it. Meanwhile, in Hank Brennan's affidavit, he misspelled his own name, Hank Brennan, okay? But here's
typographical errors.
Here's a funny thing I want to show you. Look at Attorney Yannetti's face as Alessi is talking about this hash value thing. There's actually video of this where he's serious, and then he just starts laughing every time Alessi says like one of these punchy things, okay? And Robert Alessi again pointed out that Jen McCabe did 4,560 Google searches on her phone, and that the only one that was deleted, which one, Kevin?
House Long to Die in Snow.
At
2:27
a.m. Right. Okay.
Should I make you a thing, like a stinger that is just House Long to Die in Snow?
That would be funny.
And you can just keep pressing it?
That's right.
Keep pressing the button?
That's right. Now, I want to get a little bit into this Cellbrite changing its software thing.
Mm-hmm.
I had a whole analysis of it and write up of it, and I was just checking my facts. And you know who else had a whole analysis and write up of it?
Who?
It was Olivia Lambeau, a former prosecutor who's
Right.
now like a TikTok and Twitter legal analyst who has very much gotten interested in this case. By the way, the anti-free Karen Read people are saying that she's obviously biased because she worked at the LA District Attorney's office, and so did Alan Jackson. Okay.
Yeah, that's it.
So basically, here's her analysis in short. The Commonwealth, after paying an employee of Cellbrite, a law enforcement-centric tool, to change a feature in an update to one of its programs to comport with their narrative that Jen McCabe's incriminating search didn't happen, subsequently limited its request of its expert to only have her analysis use this forensic tool. So basically, they had this guy do this software update, and then they told Jessica Hyde she could only use the analysis using the new Cellbrite software update, okay?
Mm-hmm.
So the Commonwealth has now asked its expert to abandon the very industry standard of using multiple digital forensic tools to analyze the data to now only use one tool and its specific update, which was changed without explanation by the Commonwealth's own expert, Ian Whiffen, only after they hired and paid him for their case. Now, keep in mind, he works at Cellbrite. He is the developer of this. As I mentioned, Hyde's whole report was about whether or not, the 227 search happened. And she saw it in every tool except for the Cellbrite tool. And then her opinion was that it didn't happen at 227 a.m. I think that's important to note. Although Jessica Hyde was a good witness, I wouldn't say she was a bad witness. I just think that she was under a lot of pressure to say things that questions were leading her to in the trial. So this is really interesting. The challenge that the state wanted to do to put him on the stand, to have him cross-examined for ever many days that, like the dog bite expert did.
Mm-hmm.
Judge Bev Canoni ended up denying that request after this hearing. So that is not happening. Now, keep in mind, we don't know if that means she'll allow him in as a witness or not, but we do know that she's not willing to sit around and wait for another hearing on this matter. So do you think that she will let him in or not, Kevin? Do you have any guesses?
I'm guessing she won't.
All right.
Because she sucks like that.
Yeah, I guess we'll have to see. Now, Kevin, a lot more happened at this hearing. There's more going on in this case, obviously. But the good news is we have lots of opportunities to update you and our audience on those things because some dates have been put on the calendar.
Oh, good. By the way, I'm just going to ask, we haven't heard from the appellate court on the issue regarding the jury verdicts,
Correct.
right? We're
Absolutely.
still waiting on that one. Okay.
All right. Upcoming dates in the next weeks. February 6th, there will be a motion hearing on other motions filed by both the Commonwealth and the defense.
Mm-hmm.
February 11th, the motion to dismiss is due by the defense. They have said that they're going to do a motion to dismiss based on egregious misconduct.
Yeah. Okay.
So we should expect that February 11th. And then February 18th, there will be a hearing about that motion to dismiss.
Okay.
March 4th and 5th, there will be hearings on all other evidentiary motions. March 7th, 8th, and 19th, more hearings on motions plus the final trial conference. And again, the trial date is now listed on the docket as April 1st.
All right, we'll see about that.
We'll see about that. There seems to be a lot to go through that could push that off, but I guess we'll find out.
I doubt she's going to dismiss.
Yeah, I will say a couple things.
Mm-hmm.
I would really encourage the audience of this podcast to watch some of Friday's hearing. I will find a link for it and put it in the show notes. Friday's hearing is not as long as the dog bite one, and it's not as specific.
Mm-hmm.
It really illustrates, one, how really off-base, weird, and what's the word I'm looking for when somebody speaks down to another person? Demeaning. Patronizing. Hank Brennan's affect is in court. And granted, that little tape I played you of Alessi, he also sounded kind of patronizing, right?
Mm-hmm.
But he's also talking about things that are true.
Yeah.
Hank Brennan just says stuff that isn't true in a demeaning way, and acts like that's a legal argument. And you see him doing that really in spades at this hearing. It's incredible. And then the other thing that listeners will see if they watch a little bit of this hearing is how incredible of an attorney Robert Alessi is. He is so good. He's without a doubt the best attorney for the defense I have seen in this case, and a lot of people agree with me. He's on point. He picks up on things in the moment and gets right to the heart of the matter of why those things are important and why we should pay attention to them. I cannot wait if there's another trial to see this guy in front of the jury. I cannot wait. And Kevin, you shouldn't be able to wait either, because it's going to be quite a trial if it happens.
I hope I don't need to.
I hope so too. All right, Kevin, I think that's going to do it for now. If there are any other things that you'd like me to update you on that I didn't cover here, I know there's other stuff, but I really wanted to hit the high points and the most interesting points. Please leave a comment under the Patreon episode, and I will make sure to add them to our next edition of the Readathon. Kevin, does that wrap it up for us today?
Yeah, that's it for the Readathon.
Thanks so much for joining me.
Partners in Crime Media.